citation for AR and the Chief Constable of Greater Manchester Police.
Just before you start, Mr. Southey, we have made an order that no one shall publish or reveal the name or address of the appellant who is the subject of these proceedings, or publish or reveal any information which would be likely to lead to the identification of the appellant or any member of his family in connection with these proceedings. Now, Mr. Southey.
Thank you, my Lord. May it please my Lord, I appear with my learned friend Ms Davis for the appellant in this matter. My learned friends Ms Richards, Queen's Counsel, and Ms Dobson appear for the respondent Chief Constable. My learned friends Mr Moffat, Queen's Counsel, and Mr Knight appear for the Secretary of State. Can I start by sort of getting into the before getting into the detail of this, by just making one sort of overarching preliminary point. In my submission, in a human rights context such as this, it is important, or it can be important, not to lose sight of what's in issue. Now, technicalities matter, and the arguments in this case about the technicalities are obviously important, but one shouldn't lose sight of the underlying context, and the underlying context in this case is striking. This is a case where the appellant faced trial for a serious allegation. He was acquitted. That acquittal was subsequently disclosed. The fact of disclosure does give rise to a suggestion that there is a doubt about innocence. If innocence was certain, there'd be no basis for disclosing. The only basis upon which the allegations could be relevant is if there's a risk of them being true. And they were disclosed with that suggestion that there may be truth in the allegations without advanced consultation, without consideration of the full details of the underlying evidence, and perhaps most importantly, in circumstances in which, according to the Deputy High Court judge, and this finding hasn't been challenged, all that could be said is that the allegations might be true. And that's important because on the basis of that finding, they're probably not true. So the appellant was ultimately exposed to the serious consequences of disclosure, and the well-known serious consequences of disclosure, despite that high risk, essentially, that the allegations were untrue. And in my submission, one shouldn't, when knowing the detail of the case, lose sight of that, because it is an important context. Turning to the detail, what I'll seek to do is firstly address the facts in a little more detail than I've just done, then address the approach that the first instance court must take, thirdly address the role of an appellate court, fourthly address proportionality, and then finally address the procedural issues. Starting with the facts, they are obviously fully set out, or pretty fully set out, in the Statement of Facts and Issues. The relevant passages, I think, are at memory stick page 47 of the core volume. The background, as I'm sure the court is familiar, is that there was an enhanced criminal records check issued on the 22nd of March 2011 after the appellant applied for a job as a lecturer. There was, before that disclosure, no consultation with the appellant. He was only able to put forward his case, essentially, in the context of an appeal. And that appeal took two stages, although there was an overlap in terms of personality between the two appeals. The second appeal involved Inspector Canaston, who was also involved in the first appeal. At the time of the appeal, essentially the material that was available to the police was that there was a transcript of the evidence of a forensic scientist, and there was the judge's summing up. That isn't a matter that's in the Statement of Facts and Issues. The reference to that is in the High Court judge's judgment at paragraph 10, it's memory stick page 174. The reasoning for rejecting the second appeal, in some senses, is the key reasoning, because it was the same reasoning that essentially was relied on when issuing the second enhanced criminal records check that is the subject of this appeal. And that reasoning is set out in paragraph 4 of the Statement of Facts and Issues, starting at memory stick page 47. And that reasoning started, certainly on the findings of the High Court judge, with an error, in the sense that the reasoning started, as one sees by the first bullet point within it, with essentially a finding that the CPS decision to authorise the charge, to use the language of the reasoning, indicated that on balance of probabilities the allegation was more likely to be true than false. And that's a difficult starting point to justify for two reasons. Firstly, as the High Court judge accepted, that's not a reflection of the test. The test is a different test. The test is about whether or not a jury is more likely than not to convict. It's looking at what the impact will be on a jury. The second problem with it...
Is it even that?
Well, that may be I may be oversimplifying it.
Yes.
It's the reason why I used more likely than not to convict was because I think, if I remember rightly, the authority in Gujra, the authority of this court, or the judgment of this court in Gujra, indicated that they were closely related. That the concept used, I can't, off the top of my head, remember the exact language used in the CPS test.
Right.
Reasonable prospect of conviction is the language actually used in the CPS test.
Absolutely.
Yes.
Plus the public interest question, which doesn't arise.
Doesn't arise. No, that's obviously not what was the focus was on. The second problem with using that as a starting point is, of course, things moved on from the point of time at which the CPS had taken their decision. By the time the police were considering that evidence was given in the criminal trial, that had been rejected by the jury, at least applying the criminal standard of proof. But more importantly, in some senses, inevitably, there was more material available, because the way in which evidence would be advanced at trial is going to be different to the witness statements considered by the CPS. So the High Court judge, I can give the reference, it's at memory stick page 187, I don't think we need to go to it at the moment, paragraph 40A, indicated that he accepted that the police reasoning started or proceeded on a false premise. What then happened was that the reasoning essentially looked at points essentially that could be put and were put forward in favour of non-disclosure, and essentially rejected them. So, for example, at the top of page 48, by the first bullet point, there was reference to the fact that another male's DNA was found on the complainant's underwear, but it was noted that that might potentially be explained by the fact that the complainant had indicated that they had had sex 6 weeks earlier. And it would all depend on how often the item in question had been washed. Now, two features in my submission of that reasoning that are significant. Firstly, we do maintain that there is a difference between the approach that's adopted in this reasoning and what might be described as completely balanced and open decision-making. The reason for that is essentially what is the approach that is adopted is to look at points that might be said by the applicant to sort of justify departure from what is identified as the starting point, namely the CPS decision, and then essentially to reject them. The second point we'd make, which is consistent with that, is that it is striking that throughout the reasoning, the complainant is referred to as the victim. Now, that first point, though, that I made about how the structure of this decision is essentially to look at things that can be put forward on behalf of the appellant and then essentially find ways of rejecting them is clear from what happens later in the reasoning in relation to consistency. The reasoning of the police in relation to consistency is to note, for example, that there were inconsistencies in the evidence of the complainant, but to say, well, that's explained by the fact that she accepts she was intoxicated. In contrast, it's indicated that the applicant's consistency can be explained by the fact a lying man can be consistent. So one sees points essentially being identified and then being discounted. That led to a finding, second finding, which the judge, on the face of it, appeared to find wasn't made out. That finding was that the information was more likely to be true than false. That's at page 49. It's sort of by letter C. It's the bottom bullet point within the reasoning. The approach of the judge, which is at memory stick page 188, paragraph 40D,
Yes.
Was to conclude, I do not consider that a firm or reliable conclusion as to whether the complainant's account is more likely to be true than false can be gathered from the transcript alone. I am quite satisfied that the Chief Constable was fully entitled to conclude that it was not lacking in substance and that it was reasonable to believe the information might be true. That's a reference back, if one goes back to page 49, lower bullet point, to the fact that the reasoning of the police might be said to be a little confused in one sense, in the sense that they start by using the language more likely than not to be true, but then go on to use the language of might be true. But on the face of it, one can't discount the possibility at the very least that their findings were based, at least in part, on this finding that it was...
Sorry, where's that quote from?
If one goes back to page 49, by letter C, it's the paragraph I started from, which is sort of the end of the reasoning. It's the third bullet point within the reasoning.
Well, do you say that that was a finding that wasn't open to the reviewer?
Well, the High Court judge clearly concluded that it wasn't open to the reviewer, and that finding hasn't been challenged, and we would submit his reasons for that are correct, which is it's very difficult for the reviewer to conclude it's more likely than not for the allegation to be true when they had such limited information, essentially.
But I mean, the paragraph you cited on page 49 is saying two different things, and one is saying more likely to be true, the other is saying reasonable to believe it might be true. And the judge is saying, well, I accept the second but not the first.
Absolutely, absolutely. But obviously part of the reasoning of, that's why I was saying it, to some extent that paragraph is confusing.
Yeah.
One can't avoid that conclusion. But the police's reasoning does appear to be influenced by both aspects of that finding. And that is important because it indicates in my submission that on the judge's finding there were two significant errors in the approach of the police. The first was they started from the wrong starting point, and the second is when they come to the end and make findings as to how likely it is that these allegations are true, again on the judge's findings they make significant errors. And that's important when one comes back to the approach a first instance court should take to proportionality. Obviously, we would also argue there was a third flaw in the reasoning. This is not a flaw that the High Court judge accepted, which is that the CPS decision-making essentially was lacking in balance for the reasons I've already indicated. It was working from the starting point that was flawed, which was the CPS decision-making, and was looking at whether or not there were reasons for departing from it, and essentially in that context discounting the positive things that could be said on behalf of the appellant. Should say that one other aspect of the lack of balance that one can highlight is the fact that this was, of course, was an appellant of good character, or this was a person of good character. That doesn't feed into the decision-making, but is obviously of some relevance. The decision went on, as is recorded in the Statement of Facts and Issues, to consider proportionality, and at page 49 by letter F, considered in particular the impact on employment, and essentially the conclusion reached in the bullet point by letter F that starts, although disclosure of this incident will have an impact on the applicant's human rights. In that paragraph, the essential conclusion reached is essentially that that impact is lessened by the fact that the applicant can, or the appellant can, apply for a job that doesn't involve a criminal records check. Now, that in some senses implicitly recognises quite how significant the impact is, because it recognises that the applicant is excluded from jobs that do involve criminal records checks. And that's important when considering proportionality.
Well, enhanced criminal record checks.
Enhanced criminal records checks, but they're obviously fairly widely
Absolutely.
fairly common. That was the reasoning, as I've already indicated, that was essentially relied on to justify the second enhanced criminal records check. The key wording in that criminal records check is in the Statement of Facts and Issues at page 50. It's paragraph 7. And the language used in the first paragraph reflects the statutory test in that it indicates that the information regarding the acquittal may be relevant. And as I say, we would submit that's significant because although it is, in one sense, merely a restatement of the statutory test, logically, the only reason it could possibly be relevant is because there is some possibility that the allegation is true. And so the message essentially that the certificate carries with it to an employer is there is a possibility that these allegations are true. I mean, if the message were there's no possibility of this being true, it's difficult to see why it would be relevant to anything. That probably, that does sort of cover the matters that we would say are relevant in terms of the factual background to the appeal. I've also touched, to a limited extent, on the judgment at first instance, the judgment of His Honour Judge Rayner, Queen's Counsel. There are two other features that I would just draw attention to in passing of that judgment. One goes to page 188, memory stick page 188. Paragraph 40D within page 188, paragraph 40C within page 188 deals with the acquittal. That essentially was discounted by the judge on the basis that a different standard of proof is applicable. Now that is clearly correct, that a different standard of proof is applicable, but it doesn't mean in our submission that the acquittal is irrelevant. Because, of course, the jury was the one body that heard the oral evidence. For some reason or another, and obviously one can't tell directly what the reasons are because the jury don't give reasons, for some reason or another, the jury concluded that proof to the criminal standard wasn't present. But that did suggest that it is important to potentially investigate what happened at trial, because although one can't directly work out what the reasons for that conclusion would be, because one can't ask the jury, indirectly it may be possible to reach some conclusions because, for example, a witness, when cross-examined, may not stand up to, or may not come up to proof exactly. It is important, it does indicate that the trial process was potentially significant. The second point that we would make is that when the approach of the judge in our submission did appear to give some significant weight, essentially, at the very least, to the approach of the police. If one looks at paragraph D, subparagraph D within paragraph 40, which is still on page 188, one sees, as I've already drawn attention to, within the second sentence actually no, it's within the first sentence, but it's beyond the comma, that the judge referred to the Chief Constable being fully entitled to conclude that the allegation was not lacking in substance. It then, going over the page, one sees second line on the next page, still within the same paragraph, that the factors, the judge reaching a conclusion that the factors identified by the Chief Constable were, to use his language, reasonably relied upon. And then going down the page, in letter F, fourth line, one sees a finding that, in my judgment, the Chief Constable was justified in concluding that the potential risk to the vulnerable was essentially outweighed the detriments, or did outweigh the detriments. So one sees in my submission a degree of weight, at the very least, being given to the police decision. And I'll come on to whether or not why we say that's not correct in a moment. That, as I say, is the factual background. Next topic I indicated I would address is the next topic I indicated I would address is the approach of a first instance court, and what approach a first instance court should take in circumstances like this, where disclosure is being challenged on grounds that it is alleged Article 8 has been breached. Obviously, as is well known, I can give the court reference to it, I suspect one doesn't need to go to it. Section 6.1 of the Human Rights Act makes it clear that it is unlawful for a public authority to act in a manner that's incompatible with the Convention. The reference for my Lord's notes is Volume 2, Tab 9, Memory Stick, page 696. Now, the role of the court, obviously, in considering a judicial review is to decide whether a public body has acted unlawfully. And so, clearly in our submission, this is consistent with the case law I'll go to in a moment, Section 6 means that a court must determine directly whether there's been a breach of the Convention. That, in turn, means that a first instance court has to decide proportionality. Now, that's consistent with the case law I'm about to come to, but that case law also recognises that there is a need to give weight to the views of an administrative decision maker. And that's not, we would submit, inconsistent with the court determining proportionality. It's about recognising the expertise and also possibly the institutional competence of administrative decision makers. So to use an example in this context of enhanced criminal records checks, in L, obviously the leading case and one that I will need to come back to, Lord Neuberger, paragraph 74, it's volume 1 of the authorities, tab 5, the relevant passages at memory stick, page 535. Lord Neuberger, in paragraph 74, just below letter D, indicated that when deciding whether the balance is appropriate, it's for the court to form its own judgment, but in doing so, it should accord proper deference to the fact that the legislature represents the view of the democratically elected legislature as to where the balance should be struck. Now, 2 points I would make about that. Firstly, Lord Neuberger referred to the legislature because it was the legislature that was in issue in that case, but other case law makes it clear that that approach, essentially, of giving weight to the views of a body charged with a decision applies more generally. It's not limited to the legislature. The second point I'd make is that although Lord Neuberger used the language of deference, I would submit with respect that that's not actually the best way of describing the approach to an administrative decision. What other case law has emphasised, and I'll come to it in a moment, is that a better way of looking at this is that weight needs to be given to a first instance decision maker because they may well be in a better position to assess proportionality. And An example of that is the judgment of Lord Bingham in Huang, obviously the well-known case. One goes to volume 2 of the authorities, tab 19. The relevant passage is at memory stick page 985. Paragraph 16. Halfway through that paragraph, just below letter D, Lord Bingham noted, in the sentence starting in some cases, Lord Bingham noted essentially that there were cases where the Secretary of State had identified particular policy concerns as justifying a decision. By letter F, Lord Bingham went on to say this: the giving a weight to factors such as these is not, in our opinion, aptly described as deference. It's performance of the ordinary judicial task of weighing up the competing considerations on each side and according appropriate weight to the judgment of a person with responsibility for a given subject matter and access to special sources of knowledge and advice. So, I would submit there are three points essentially that arise from that. Firstly, in my submission, the approach of Lord Bingham explains essentially why giving weight is not inconsistent with the court determining it for itself proportionality, because it's just recognising essentially that quite often some other body may be in a better position than the court to identify what the public interest factors are in a particular case.
Well, is it solely confined to that? That they may be better placed to make a decision than is the court? Or does it have some intrinsic weight, the fact that an administrative decision maker has reached the conclusion that she or he has?
Well, Lord Bingham's language clearly recognises that there may be a need to give some weight to the fact that effectively a particular task has been given to a particular body by Parliament. I'm not saying it's just administrative sort of expertise. There is an element of institutional competence, but as has been recognised in other judgments, obviously the weight to be given may vary. And so if one has special knowledge, then we would certainly submit greater weight potentially needs to be given to the administrative decision maker.
Yeah.
The second point that I'd make is, and this is coming on to what perhaps is...
If I must interrupt you for a moment. I mean, citing Huang reminds me that we looked at this in, I can't remember offhand whether it was Hashim Ali or Agyarko, but in one or other of those cases, I think it was Hashim Ali, we looked at the fact that the court was exercising an appellate jurisdiction from the Secretary of State.
Yes.
And made the point that, like any other appellate jurisdiction, the court didn't begin with a tabula rasa. It began with a decision by an administrative decision maker about whether a particular interference with Article 8 was proportionate or not. And you are asking, as an appellate body, whether that was wrong. You weren't beginning, as it were, ignoring the decision. On the contrary, the decision was the starting point, and this was an appeal against it, in which it was for the appellant to demonstrate that there was an error.
Yes.
And I suppose the position on a judicial review, if anything, I might thought would be stronger. It can't be any weaker than that of on an appeal. Because at least on an appeal, you are competent to look at the merits.
Well,
No.
That's the point. This was in the context of immigration judges who are there to remake the decision of the administrative decision maker. Judicial review, whatever it is, and that we can debate forever, is somewhat different.
I don't. Can I make it clear? In one sense, I'm going through this bit relatively quickly because I'm going through it because I don't dispute that it's not that one sort of. I'm not arguing that one should ignore or not give weight, to use the language of Lord Bingham, to the decision of the administrative decision maker
because it's being committed to him or her.
Because it's been committed to him and her, and because of their expert, for both reasons. The reason I'm drawing attention to it is, firstly, it may shed some light on what is actually probably more difficult in this case, which is the role of the appellate courts, and secondly, because it's part of the context in which one needs to look at what is actually potentially a problem in this case, which is how do you do that if you accept that how do you give weight if you accept that the administrative decision was flawed? How do you give weight? It's fine, if the police decision in this case was one where there was no proper criticisms of the reasoning, it was perfectly proper reasoning, one can see that has to carry weight. The problem that this case, but one of the problems this case throws up, is that on the findings of the High Court judge, there were flaws in that decision making, quite significant flaws, and that then raises different issues, and that's why all I'm doing in some senses is setting up, is going through what is probably uncontroversial as the background to what is perhaps more controversial in this case.
Yes.
What I've just said is perhaps covers a couple of the points I was going to make about this. But two other points that I would make, essentially. Firstly, that approach does suggest that the relationship between an appellate court and first instance court is not the same necessarily as that between first instance court and administrative decision maker. In an appellate court, in the position, one looks at the position of the Court of Appeal in this case, and I accept in saying this that the position might be different in the context of specialist tribunals, but if one looks at the position of the appellate court in this case, the appellate court was not lacking in any knowledge, essentially, that the first instance court would have, had the same material before it, and in many respects it was charged with a similar sort of process. It was ultimately charged with determining whether there was illegality.
This is your third point, is it?
That's the second. That's the second. The first point I made about it was also about essentially why it wasn't inconsistent with Article 8. The third point I've touched upon, which is that there is a problem that arises with this approach, which is how do you give weight to an administrative decision maker's decision if they've adopted a flawed decision? That, in my submission, that was not in my submission. That was touched upon by the Court of Appeal in A. And A is, in the Chief Constable of Kent, is obviously a key authority. It's one I will return to several times in my submissions. That is in Volume 1, Tab 7. And it's at Memory Stick, page 627. Leading judgment was a judgment of Lord Justice Beatson.
Yes.
Paragraph 36 and 37 set out essentially a summary of the approach and broadly set out a set of principles which are consistent, hopefully, with what I've just submitted. And in particular, what Lord Justice Beatson makes clear is ultimately, in paragraph 37, it is for the court to determine whether a decision is compatible with ECHR rights. It does that essentially in part by making its own assessment of the factors considered by the decision maker, and in particular considering what weight to be given to them. One sees that in paragraph 36.
But you need the bit about no shift to a merits review.
Absolutely,
well.
no, absolutely, no, absolutely.
Yeah.
And I don't think, certainly as far as I can see, there's any real dispute between the parties that paragraph 36 and 37 reflect essentially the correct approach. What is more significant, as I say, in the context of this appeal, given the issues that are raised, is paragraph 39 where Lord Justice Beatson looks at essentially what is required by way of giving weight to an administrative decision maker. And in particular, at the bottom of the page, in the last two lines, he says this: if that decision has addressed his or her mind at all to the existence of the values or interests which under the ECHR are relevant to striking a balance, his or her views and conclusions carry some weight. But if the primary decision maker has not done so, or not done so properly, his or her views are bound to carry less weight, and the court has to strike the balance for itself, giving weight to the judgments made by the primary decision maker on such matters as he or she did consider. Now that, in my submission, is quite important in the context of a case like this. There is, in my submission, as far as I can read, as far as I understand the pleadings between the parties, no dispute that at least in some way, maybe dispute about quite how this works, the reliability of an allegation is a relevant factor. And that's consistent with common sense. It must be much more difficult to justify disclosing an allegation which is 10% likely to be true than one that is 90% likely to be true, if it's the same allegation. Not least because if it's 90% likely to be true, then logically there is a higher risk that the person will offend because there's a higher risk they have a previous record. Similarly, if it's a 10% risk, then the interference with the individual's rights is much more significant because they are losing the potential benefit of employment in circumstances where the allegation may not be true. And so reliability is a relevant factor. Now, if the police, as they appear to do in this case, base a decision as to disclosure on a conclusion that an allegation is more likely than not to be true, and that in fact is not a conclusion that was open to them, it becomes very difficult to work out what their conclusion would necessarily have been had they approached the case on the correct factual basis. And it becomes very difficult then to give weight to that decision. In my submission, it's speculative essentially to say that necessarily the approach of the police would have been the same. And so while ultimately I accept that when looking at a decision of an administrative decision maker, one in principle should give weight to the decision reached by that decision maker when assessing proportionality, in my submission, that weight is likely to become essentially very little or non-existent in circumstances where there is a very significant flaw in that decision. One can't, otherwise one's sort of making an assumption as to what the administrative decision maker would have decided had they proceeded on the correct basis. And that's obviously relevant, we would submit in the circumstances of this case, because on the face of it, the judge at first instance concluded very significant flaws, but still appeared to give quite significant weight to the police decision making. Now, the submissions I've just made are the context in which one should consider what is perhaps one of the key legal issues in this case, which is the role of the appellate court. Can I start by saying, of course, there is no surprise that this wasn't addressed in the Court of Appeal. In the Court of Appeal, there was binding Court of Appeal authority, which was the case of A and Chief Constable of Kent, which made it clear what approach should be adopted. However, in this court, we're able to argue that A and Chief Constable of Kent does not represent the correct approach. Now, the starting point, again in my submission, when looking at that issue, is Section 6 of the Human Rights Act. And if I was correct in my previous submission that essentially Section 6 requires a judge to determine whether or not a decision is compatible with the Convention, if they get that wrong, Section 6 in our submission must implicitly also mean that they've made an error of law. I mean, to put it simply, if a judge wrongly concludes there is no breach of Article 8, and so holds there was no illegality on the part of a public authority, when in fact there is a breach of Article 8, that is an error of law. And so in our submission, that is the starting point when looking at an appeal. An appeal, in our submission, must be able to effectively look again at whether or not, or one would expect, given the Human Rights Act, an appeal is able to look again at whether or not there's been a breach of the Convention. A second feature of Section 6 supports that submission, and that is, of course, the fact that the court is a public authority. And as a public authority in our submission, it has to ensure essentially that there is compliance with the Convention, including Article 8. And there's good reason in our submission why the Human Rights Act should be interpreted in that way. Firstly, as we've made clear in our statement of case, we haven't produced this as an authority because I think it's probably trite law by now. It's paragraph 3.13 of our statement of case, memory sticks, page 61 for the reference. The court is now very familiar with the mirror principle, the need to ensure that as far as possible rights are brought home. And if one were in a position where the Court of Appeal couldn't intervene, where it was satisfied that there was a breach of the Convention, because essentially it couldn't demonstrate an error of principle on the part of the first instance judge, one would potentially be forcing people to go then to Strasbourg. And there's a second reason why we submit that's the correct approach under the Human Rights Act. Lord Bingham, and I probably again don't need to take the court to it in terms of the reference, in Huang, again, it's paragraph 18, memory stick page 986, indicated that what Strasbourg essentially does is draw a line that marks out where the Convention is violated. And that approach in our submission is consistent with both the approach of domestic courts and the approach of the Strasbourg court. If one thinks about cases like, again, I think we probably don't need to go to it, it's in the book, it's in the bundle of authorities, it's at volume 5, tab 50S, S and Marper, the well-known DNA case. Although the court gives the domestic authorities a margin of appreciation, it ultimately decides for itself whether the facts of the case have overstepped that margin of appreciation. And so it's looking at where the line has been drawn. And that, in many respects, reflects the approach domestically. If one looks at cases like T, the criminal records conviction case. Ultimately, again, this court decided whether or not the test of necessity had been met, whether the line had been crossed. And that's important in my submission because ultimately the role of the first instance court is to determine whether that line has been crossed, taking account, as I say, of properly expressed views, essentially, of the first instance decision maker, etc. And if they get that line wrong, in my submission, they've made an error of law. Now, that is the context in which one needs to consider the judgment of this court in B, which is obviously the origin of the approach of the Court of Appeal. And B is in volume 1 of the authorities, tab 6, memory stick page 539 is where it starts. And it's important in my submission to understand the context of that judgment, because that judgment is clearly concerned with the approach an appellate court should take when the first instance judge had heard oral evidence with all the advantages that they then enjoy as a result of having heard oral evidence. And our basic submission is, and I'll come back to this possibly several times, our basic submission is, to the extent that B is inconsistent with the submissions I've just made about the Human Rights Act, the inconsistency essentially becomes so narrow in cases where there is no oral evidence that it's effectively non-existent. It's of no practical effect. Now, my lords probably by now are aware, given the various pleadings in this case, that the leading judgment was given by Lord Neuberger. And the passages of his judgment that are relevant start at paragraph 83. And that's memory stick page 568. And he noted initially, which we've never sort of sought to argue against, of course, under the Convention, there is no right to appeal at all. But indicated that, at least to some extent, that begged the question of what was the correct approach of an appellate court where there is a right of appeal. And that's an important starting point, because, as I say, we don't argue and we don't challenge the points made by the respondents, which is there is no right of appeal under the Convention, but obviously domestically there is a right of appeal, and the fact there is no Convention right of appeal then probably says little about what the scope domestically of any appeal should be. Paragraph 84 then contains another summary of sort of materials of the sort of of the approach of a first instance court to proportionality, and indicates that essentially that doesn't necessarily mean that an appellate court necessarily has to decide proportionality for itself. That passage, indeed some later passages, need to be read with what follows, because in my submission what they indicate is the circumstances essentially in which a court should be very reluctant to determine proportionality. Lord Neuberger then in paragraph 85 by letter E indicated that what is required is that any appeal process involves proper consideration of the question of proportionality. And in paragraph 86 indicated that it's the second sentence within paragraph 86, that in a case such as this, essentially, that's his language, where you the phrase "in a case such as this," the role of the appellate court should be to review the trial judge's conclusions. But those two findings raise questions as to what is meant by proper consideration and what is meant by a case such as this. And the answers to that in my submission are found over the page, essentially. The first point of important, or the first passage of real importance in my submission is the end of paragraph 88, which, as I say, is over the page, memory stick, page 570. And one sees there two sentences that are important. The first essentially says that the court won't intervene, essentially, if a decision was reached by a first instance judge which he was entitled to reach. But that's then contrasted, and this is important in my submission, with the position if a judge made a significant error of principle, or, and I emphasize the word or reached a conclusion he should not have reached. And that's important in my submission, because what one sees when one starts looking at the way the Court of Appeal has started to apply this judgment, in this case and in the earlier case of A, is that the focus is on whether there's an error of principle and not on the second limb, which is whether or not the judge reached a conclusion he should not have reached.
I'm sorry, what's the difference?
Well, the difference is, in my submission, is that when one comes on to look at what Lord Neuberger then goes on to describe, he goes on to describe a focus on whether the judgment was wrong. Now, what he does, in my submission, is in that context, he recognises that where a judge has heard oral evidence, there is scope for an appellate court to say, well, I can't say whether this is right or wrong, and so I can't reach a conclusion. And in those circumstances, you shouldn't intervene. But the use of the word wrong, and the judgment read as a whole, and I'll come to further passages, makes it clear that when looking at, effectively, whether the conclusion was one that shouldn't have been reached, there is a different focus. The focus is on the outcome, essentially. The focus is on whether or not the correct result has been reached, whereas in terms of principle, it's about the reasoning.
Well, the important point, surely, is that the examination of whether the judge has reached a conclusion which he should not have reached demands of the appellate court that they address the question of what the proper conclusion was.
Absolutely, my lord.
But can that be right? If you just look at that, if on the other hand, after such review, the appellate court considers the judge made a significant error of principle in reaching his conclusion, stop there for a moment. That's a gateway, isn't it, to the Court of Appeal reassessing.
Well, that's a traditional gateway. That's
that's easy.
Yes.
It's the next bit, which is complicated. Or reached a conclusion he should not have reached. Now, the question is whether that's a gateway or simply satisfied by the Court of Appeal thinking, well, if I'd been there, I might have done it differently.
Well, my lord, that's why, in my submission, one needs to look at what follows in his judgment, because that sheds further light on it.
Is it a gateway, or is it simply starting fresh?
Well, can I? In one sense, I would say it's a bit of both. In the sense of this, in the sense that it is a gateway, but it's a gateway that's focused on result. Now, the reason I accept...
If it's a gateway that's focused on result, then at least on one analysis, it's no different from starting again.
Well, my lord, it's not in a case like B, where the court is recognising the fact that there is oral evidence.
Well, I understand that, of course.
But
if what you're saying is that everything in B is confined to cases where the judge has heard evidence, then that is something that at least I understand. Whether it's what the judge is saying, I'm not sure.
Well, my lord, the point I would make, and just again to sort of repeat almost what I said before, what I would accept, B decides that in a case where there's oral evidence, you don't just look at whether there's an error of principle, you look at whether the decision was wrong. But you recognise, essentially, because oral evidence was given, there is this category of cases where you say it can't be right or wrong. Now, our point is that if you apply that approach in a case where there is no oral evidence, where the evidence, you're in exactly the same position, essentially, as a first instance judge when you sit as an appellate court, that space for there to be a category of cases where effectively you can't say the judge was right or wrong becomes effectively non-existent, essentially.
Okay.
Well, that's the way in which I would put it. So it's not saying that effectively B is confined to its facts. It's just that if you apply the approach in B in circumstances where you don't have the particular problem that was present in B, which is how do you, as an appellate court, deal with the fact that the first instance judge had advantages in hearing oral evidence, if you apply that approach, the problem area, which is the situation where you couldn't say whether a judge was right or wrong, essentially becomes non-existent. Well, the fact that the court was concerned, essentially, with the approach to oral evidence is clear at several passages. Carrying on through this in sort of the order in which the judgment is written, paragraph 89 indicates that one reason for the approach that was adopted in the case was the fact that the trial judge would have had the advantage of a full opportunity to assess primary facts and make relevant assessments. And so one sees there, and one sees it in further passages that I'll come to, a clear concern being expressed that the approach needs to reflect that advantage that a trial judge, where there's been oral evidence, has. Now, the phrase wrong effectively comes in first, I think, at paragraph 91, where in paragraph 91 by letter H, Lord Neuberger indicates essentially that an appellate court should not intervene unless essentially the judge at first instance was wrong. He rejects in that context any qualification of that by use of the word plainly wrong. Now, there are a couple of features of the judgment, perhaps three or four features of the judgment, which perhaps shed light on what was meant by wrong. Firstly, if one goes to paragraph 92, one sees by letter C, Lord Neuberger is very clear, essentially, that what he's talking about are the particular issues that arise when a court is looking at the issue of proportionality. Makes it clear that where convention questions such as proportionality are an issue, that an appeal court should intervene if the judge was wrong. So he is, in my submission, implicitly recognising that a different approach is required in a convention context, and that's, in my submission, consistent with Section 6. He then, as I say, repeats essentially to a large extent what was said earlier, where he says that finding that the judge was wrong is a sufficient condition for allowing an appeal. He then goes through, as is perhaps well known, in paragraph 93, the identification of, I think, 7 categories of case. And that is important in my submission, because if one looks at those categories, the first of those categories, essentially, and the last of those categories, considers a situation, or perhaps actually the last of those categories is the more important, because it considers a situation where the view reached by the trial judge was unsupportable. Now, that's the traditional sort of like Wensbury lacks any reasonable foundation type approach to sort of the approach of a trial judge. But Lord Neuberger's quite clear that that isn't the only circumstance in which an appeal should be allowed. On his reasoning, essentially, category 6, which is merely a conclusion that the judge was wrong, and indeed category 5, which is where there's doubts as to what the outcome was, but on balance the judge was wrong, is a sufficient ground for allowing the appeal. Now, in relation to category 5, paragraph 94 makes it clear that, of course, the judge, when looking at whether a case is a category 5 case, has to bear in mind the fact that the judge heard witnesses and heard evidence, and that is a potential advantage. But the conclusion still is reached. If this is a category 5 case, the appeal's allowed. Now,
it's all very complicated, isn't it?
well, I'm not
I don't
disputing.
remember a case where I've gone through this process of finding 7 different versions of the possibility, and then where I get is.
I'm not disputing that, and
There we are. I'm learning, I know.
my lord, it's not really for me to say, but
No, of course.
but it is.
Anyway, I see what your point.
But the point is, this is not on the face of it, and one.
I mean, your basic point is that it obviously makes a difference where there are witnesses and the judge has heard them. I mean, that's very
But
basic.
absolutely. But the only essentially, well, that's one of my points. The other point is what is meant by wrong, and wrong can only mean in these
But
circumstances.
you're looking for something which is, well, called an error of principle, or something which has gone wrong in a sense. You would say in this case that a primary decision maker has actually made some serious mistakes of approach. But
Well-
if you've got that, then I can see the court will intervene.
Well, but I think I would go further than that in the sense that I would submit the distinction that's drawn between error of principle and wrong, if one looks at this in context, is that wrong is focused essentially. Error of principle is focused on process. Wrong is focused on outcome, and wrong is looking. And one can only assess whether the decision was wrong by essentially concluding what conclusion you as an appellate judge would have made. And that's entirely consistent with paragraph 94. And paragraph 94, if one looks at it, is essentially, particularly when there is consideration of category 5, paragraph 94 is essentially saying that what a judge who thinks they have a case in category 5 must do is that they must take account of the fact the trial judge had heard oral evidence, but ultimately decide whether or not they disagree with the judge. And so it's focused on outcome in my submission. And there are other indications that that is the correct approach in my submission. Firstly, if one goes to paragraph 95, my Lord Kerr, I'm sure, will remember that my Lord was in the minority in this. There was a 3-2 split, essentially, and my Lord Kerr, as well as Baroness Hale, were in the minority in relation to it. And paragraph 95 is where Lord Neuberger looks at the differences between his approach, essentially, and the approach of Lord Kerr. And what he indicates in paragraph 95 is that the differences are likely to be rare. And Lord Kerr, as my Lord will remember, and I'll take my Lords to it in a moment, essentially concluded that it was for the appellate court to conclude whether or not a decision was proportionate, giving weight to a first instance judge, but one should decide whether or not a decision was proportionate. And Lord Neuberger's sort of response essentially to that is to say two things. Firstly, in fact, there are unlikely to be many cases where that there is a difference in outcome. That implies, in some senses, that what Lord Neuberger is recognising is that his focus on whether or not a judgment is wrong is closely related to the issue of whether or not it's proportionate. Essentially, the only disagreement was whether or not there was this category 4, where you can say a decision was neither right nor wrong. But secondly, and equally importantly, he then goes on to say that the advantages of a trial judge are primarily in relation to primary fact-finding and less important in relation to proportionality. And so in that context, effectively the advantage may become less significant and may become very little indeed. And that's why he says, in practice, there won't be many differences. So what he's saying is if effectively you don't have those advantages, and in this case you don't have those advantages, the scope essentially for there to be a category 4, which is a category where you say it's neither right or wrong, becomes very narrow indeed, if not non-existent.
Well, it does. What about the point that he makes at 84, with which all this begins? That if it's wide open at each successive level of appeal, every case can go on until you get here.
Well, obviously...
or indeed Strasbourg. Keep it domestic, here.
Keep it domestic. Well, obviously, this court applies a slightly different test in terms of its leave. But in terms of the Court of Appeal, the answer to that is, it's still...
We apply a slightly different test on the question of leave to appeal, partly because, generally speaking, we are not engaged in pretending that we're first instance judges, much as some of us would like to.
Yeah. But the answer to it is that as my Lord Kerr recognised, it doesn't mean one doesn't give some weight to the views of the first instance judge, and it doesn't mean one doesn't recognise that essentially the first instance judge will have heard argument and reached conclusions. And I mean, the reality is that particularly at the permission to appeal stage, if you've got a fully reasoned judgment of a first instance judge, that although one is in principle, on my argument, able to say this was the wrong conclusion, one's going to, in practical terms, have to demonstrate that there is a reason why the first instance judge should not be followed. But that's not the same as saying that the actual process that the Court of Appeal is actually tasked with is not ultimately the determination of proportionality.
Well, I think your submission resolves to this, does it not? If you're addressing the question whether the decision maker was wrong, that whatever connotation one places on the word wrong, it does require some evaluative assessment by the court that is considering that question.
Absolutely.
As to whether the decision was right or not. And that necessarily involves something more than simply deciding whether there was an error of principle.
Yes. And my Lord, that's, with respect to my Lord, it's the point my Lord made, in fact, in B. If one goes to paragraph 127, there's the...
Well, I think we have to remember that I was in the minority.
One does, my Lord, but my Lord did say some things in paragraph 127 about what is meant by wrong. And ultimately, in my submission, although I completely accept my Lord was in the minority, and I'm not seeking to re-argue necessarily that my Lord was right. What I am entitled in my submission to submit is that once one is in this situation where there is no real advantage enjoyed by the first instance judge, both my Lord and both the approach of my Lord to what was wrong and the approach of Lord Neuberger to what was wrong, it demonstrates that in fact there is little gap between the approach my Lord adopted and the approach of Lord Neuberger, and this category 4 becomes very little.
I mean, it's paragraph 127 with respect is very simple for me. Well, I'm trying to find out from all those paragraphs you've been
One
reading.
always strives for simplicity, but doesn't always achieve it.
I mean, it said there's not much difference, but I'm still slightly unclear what the difference is. But anyway.
Well, my lord, if just to try and put this another way, where I would accept there is a difference, what I would say is that is effectively the ratio of B is this. If you have a case like a family case,
Yeah,
where
no, I
there was,
understand that. The case where you've got evidence, put that on one side. Case where you don't have evidence, where the material is the same material,
what?
is there any difference on your submission?
Well, there is in principle a difference between the approach of my Lord Kerr and Lord Neuberger, because Lord Neuberger, as I say, recognises in principle there is this category 4, using his language, where one can say the judge may have been right, the judge may have been wrong, but I can't be satisfied. My point is that case that it becomes sort of extremely unlikely, if not impossible, to actually find a case in those circumstances where the court actually has exactly the same material as the first instance judge had, because the court is going to carry out an exercise to assess whether there's right or wrong, of looking at what its own conclusions would be, and it becomes very, very difficult.
You say category 4 only comes into play in a case like B, where you've got oral evidence and
Exactly.
a different
Exactly.
material. Yep.
Exactly. And so the difference between my Lord Kerr and Lord Neuberger becomes effectively academic in a case of this nature.
I understand that. Thank you.
Yeah. My Lord, in any event, what the approach of the Court of Appeal, which is the approach that was essentially applied in this case, has become more narrow. And if one turns back to A, which is at same volume, volume 1, tab 7, and the relevant pages are at memory stick page 642. One sees, following a consideration of B, paragraph 90, it being concluded that unless the court concludes the judge erred in principle in her approach, it's not required to reconsider proportionality. Now, that on the face of it completely cuts out the second limb in B. That was the problem that the appellant in this case faced. This was, A had been decided, A was binding authority, but A on the face of it cuts out the second limb, which is the limb that brings in this issue of wrong, whatever is meant by wrong. Now, what's also interesting about A is in A, the conclusion was reached that the gateway had been crossed, or that there were grounds for reconsidering the decision. And the Court of Appeal, in fact, as a matter of practice, had no problems reconsidering proportionality because it had exactly the same material as the High Court judge, and one sees that at paragraph 93. But it was only doing that because an error of principle had been established, and that was the test that it set itself. And certainly our submission is whether I'm right or wrong about category 4 essentially falling away in cases like this, that is too narrow an approach, because it doesn't reflect at all Lord Neuberger's approach that essentially recognises that there is a second basis for intervention, which is a decision being wrong. And that then fed into this case, the approach in this case, and it's in the core volume, page 166, memory stick, memory stick 166, it's page 7, paragraph 74. One sees, this is the sort of end of paragraph 74, one sees last sentence, when the judge's decision is challenged on appeal, the appellate court will only consider the issue of proportionality for itself if it finds the judge has made a significant error of principle. Well, that is an unobjectionable statement of what was said in A. It's unsurprisingly because A was clearly binding on it. but again suffers from the same problem, that it doesn't reflect the full extent of Lord Neuberger's reasoning. And one sees how that had how that was applied, because one sees at the end of paragraph 75, the court directing itself that the judge correctly directed himself to the material considerations. In 76, the court shouldn't be drawn into remaking the decision.
Yeah, at the end of 76, Justice McComb says, I can see no significant error of principle in the point he's just discussed, and can see no reason to disagree with the assessment of proportionality that he made.
It's looking at whether the judge's approach was flawed or not. If one looks, as I say, earlier on in that passage, it's quite clear he was indicating that he shouldn't be, to use his language, shouldn't be drawn into remaking the decision. And paragraph 75 focuses on whether there were any misdirections in terms of material considerations.
Of course, Re was not binding on the Court of Appeal if it was inconsistent with B.
Well, my Lord, because it was an interpretation of B, I'm not sure that would be right, because it was the Court of Appeal's, interpretation of B, and so
Well, we don't need to debate that. I mean, it's
yes,
quite an interesting point.
yes. So certainly, and if I'm wrong on that, that was decision. That's my fault. But certainly, my understanding would have been that because it was an interpretation of B and it was an application of B, then it was.
Well,
Anyway, we're not bound. So.
Yeah. Can I just two points which I anticipate just very briefly, and I'm conscious of the time, that I should just touch upon. My learned friends drew attention to the judgment again of my Lord Kerr in DB. In our submission, DB doesn't really touch on this. It's about it wasn't concerned with the approach to the Human Rights Act and proportionality. So in our submission, it doesn't take one any further. Secondly, my learned friends place quite a lot of weight on the civil procedure rules, but ultimately, of course, the civil procedure rules, interestingly, in some senses, reflect the language of Lord Neuberger, because the civil procedure rules talk about allowing an appeal if the decision was wrong. The question is, what is wrong in this context? So in our submission, as I say, effectively, the approach of the Court of Appeal was wrong because it was focused on whether there was an error of principle. In our submission, the Court of Appeal, in a case like this where it had the it had all the material essentially available to it that the first instance judge had, should have assessed proportionality for itself. There was no particular advantage enjoyed by the first instance judge. There was no basis for essentially saying the judge may have been right, the judge may have been wrong. If we're wrong in that, we have identified in our statement of case reasons why we would submit in any event there were errors in the approach of Judge Rayner, and probably don't need to repeat them at length. Justin?
You have. Can I just go back to that? Because you're right about the last submission, it may not arise, but if by chance you weren't.
Yes.
Do you say that he has, at any point, made his own decision about the proportionality?
What, his Honour Judge Rayner?
Yes.
The approach he's adopted, at the very least, I would say, can I sort of put a slightly nuanced answer, because I want to sort of put it as low as I think I need to sort of make good my point. Yeah. At the very least, he's either, well, I can put it in two ways. He's either effectively adopted a traditional review approach, or if he hasn't adopted a traditional review approach, what his language indicates is he's given very significant weight to the approach of the police. And either of those is an error. It's a slightly different error. Yep. The first approach is an error because ultimately the question of proportionality was for him directly. Alternatively, it's an error because essentially the police decision was flawed for the reasons I indicated, and as a result...
I've got that.
Yep.
I was looking at 90F. I think it's 90, isn't it? Sorry, 40F of his judgment.
Sorry, yes, I was...
I've got the page. It could be about 49, 50, I think.
It's 189, I think.
Yeah. All right.
Memory stick 189.
You've made the point that at 40D, he, on your submission at least, has simply addressed whether the Chief Constable was entitled to conclude that the allegation was not lacking in substance and might be true. Then he goes on to say, in my judgment, that is a sufficient basis for disclosure subject to proportionality. And then proportionality he comes to, does he, in F?
Yes.
And you make the point that his second sentence includes language of review. The Chief Constable was justified in concluding. What about the next bit? Last 4 lines on the page as I'm reading it. I am satisfied that the disclosure in the March certificate was no more than was necessary to meet, etc., etc. Now, what's he doing there?
Well, in my submission, that sentence has to be read with what precedes, and it
by what it precedes.
Absolutely.
Okay.
And why isn't he doing just what Lord Newberger said he should do, which is ask first, is there an error of principle in what the Chief Constable decided? Secondly, was it wrong?
Well, that's why I put the answer to my Lord Hughes's question in 2 ways. In my submission, either what he's doing in this judgment, when one reads the passages I've highlighted as a whole, is conducting what in practice was a review exercise, or if he's not doing that, he's giving very significant weight to the police decision-making, which in principle might be acceptable if it weren't for the fact the police decision-making had flaws in it.
So I don't understand that. Why is the last sentence of paragraph F not his view on proportionality?
Because the reasoning he is relying on to reach that conclusion essentially is what precedes it, and what precedes it is reasoning which in several points effectively suggests a review approach. But as I say, if I'm wrong, if he isn't conducting a review exercise, at the very least, what he must be doing with the passages I've indicated is giving significant weight to the approach of the police.
That was flawed.
And that was flawed.
Well, I think we've probably exhausted this subject.
Yes.
Haven't we?
Can I move on very quickly, given that I am conscious of the time and I've got 10 minutes, so I will go through, and that covers probably the sort of most difficult legal issues. Can I turn to proportionality? Obviously, in our submission, there are 2 possible reasons why the court needs to assess proportionality. If we're right about the role of an appellate court, then that would suggest the court needs to assess proportionality. And certainly we would submit one needs to assess proportionality to decide whether or not His Honour Judge Rayner was wrong. Alternatively, if the court accepts my submission that His Honour Judge Rayner made errors of principle, and I've identified those in our statement of case, that would also suggest that one needs to assess proportionality. Now, in proportionality, there's no real dispute between the parties. It's a balancing exercise. L decides that. The reference to L is Volume 1, Tab 5. It's memory stick page 527, paragraphs 42 and 45 is where Lord Hope sets out what is, I think, generally agreed by the parties, which is essentially one needs to balance the interests of the individual against the interests of society.
Just give me that citation again, please.
Sorry, it's paragraph 42 and 45, 45 in particular.
And the MS number?
527.
Thank you very much.
Lord Newberger also said a little more about the topic, and in particular indicated that paragraph 81, reliability was a factor. The Supreme Court also in that case indicated, perhaps unsurprisingly, that, of course, one reason why one needed to approach cases of this nature with care is that the effect of disclosure can be drastic from an individual's point of view. It can cut them off from a very wide range of employment. And of course, in this case, one had a situation where the appellant had applied for 2 very different jobs, but both of which essentially required a criminal records certificate. And in that context, one also needs to remember the point that was made by Lord Newberger and repeated essentially by Lord Wilson in T, which is one can't assume necessarily that employers won't be risk averse. This is a culture where employers are likely to be risk averse, and disclosure, one can't assume that the employers will necessarily make properly balanced judgments in this context. So harm can be done even when context is not required. Sorry, even when there isn't justification. Now, that's context in some senses of one of the key factors we rely on in proportionality, and I won't repeat it, but we do draw attention to the fact that His Honour Judge Rayner concluded that the allegation merely might be true. And that, in our submission, is an important starting point, because reliability is a spectrum, and if it is towards the bottom end of that spectrum, that suggests a particularly powerful justification is required. And that's reflected in the statutory guidance. Now, the statutory guidance wasn't in force and at the material time, but in our submission it remains relevant, in part because it demonstrates what's necessary. As the court will be very familiar, necessity is a key aspect of proportionality. My Lord Kerr, for example, indicated that in B at paragraph 115. And if the state has indicated in the form of guidance that disclosure is only needed in certain circumstances, it becomes difficult to argue that it's necessary to disclose in other circumstances. The guidance is in tab 5, volume 5, maybe worth turning to quickly. Volume 5, tab 53. Paragraph 16, memory stick page 2041. Paragraph 16 is the passage that deals with credibility. And in my submission, paragraph 2, which says chief officers should consider whether they're, sentence 2 within paragraph 16, which says chief officers should consider whether there are any specific circumstances that lead them to consider the information is unlikely to be true, whether the information is so without substance it's unlikely to be true, it is concerned...
Sorry, which paragraph are you reading from?
Sorry, paragraph 16, 18, sorry, sorry, my lord, it's, my notes have covered up the number. Paragraph 18, yes, it's the middle sentence in that. And paragraph 2 in my submission implicitly essentially recognises that the point that I've made several times this morning, which is that it is a pretty draconian step, essentially. It's a pretty radical step to cause the significant harm that can be caused by disclosure in circumstances where something is unlikely to be true. Now, it's not ruling out that, but it is recognising that the extent to which an allegation is likely to be true or unlikely to be true is a highly significant factor, potentially.
Should not be included without taking reasonable steps to ascertain whether they are more likely than not to be true.
Well, my lord...
How am I to read that if I'm the inspector doing the job?
Well, my lord, in my submission, what this is about is two separate but related...
Not a question that's really...
No, but can I... Ultimately, obviously, the court has to give an objective interpretation of this policy, even if it's not well drafted. In my submission, what this is about two related concepts, but two separate concepts. Paragraph 2 is about whether, in fact, something is likely to be true or not. It's about the point I just made, which is it's a relatively draconian step to require something to be disclosed when it may be untrue. And sentence 3 is about a linked point, which is because of that, if you are considering it, and of course this is statutory guidance, it's not an act, it doesn't prohibit disclosure. If one's going to consider disclosing in circumstances where something is unlikely to be true, at the very least one has to carry out a particularly rigorous investigation of that to see whether or not in fact one can reach firmer conclusions about reliability. One shouldn't just sort of rush into disclosing something that's in my submission how one should interpret it. And that has implications in two ways, essentially, in the context of this case. Firstly, it supports the submission I've already made about how radical it is a step to disclose material in circumstances where it may be untrue. But secondly, and linked to that, it makes the point, essentially, that it was particularly important that there was full information such as a full transcript of the evidence that was considered before disclosure took place, because it is an unusual step. That essentially is, particularly given time, probably all I should say about proportionality at this stage. What we're ultimately saying is this was a case where what happened was that there was disclosure, as I started with, of an allegation that may well not be true on the findings of the High Court judge, in circumstances where the information about the trial was limited. Before the first disclosure, there hadn't been any consultation. And I'll come on now to the procedural point.
Mr. Southey, before you do that,
Yes, sir.
on the guideline, am I right in thinking that there was no guidance in force at all
No,
at the time of
absolutely.
this decision?
Absolutely.
So on what basis do you say we should take account?
It's for this reason. I made the submission earlier that a key aspect of proportionality is necessity. If effectively the state has demonstrated it doesn't need to disclose in these circumstances by producing guidance saying these are the sort of circumstances one should disclose, these are the circumstances one shouldn't, that then should feed into necessity. And there is I didn't, because of time, go to it, but in our statement of case, for example, we draw attention to an example of that approach, where Lord Wilson, in the T case, which was about criminal convictions, relied in part on the fact that the Secretary of State had been able to revise the system as part of the justification for concluding that the system that was before the court, which was a historic system, was disproportionate.
Thank you.
Yes.
Lord, procedural, I can deal with very, very quickly. The simple point we make about this is that the judgments such as L emphasise the importance in being consulted before a decision is taken. And there is good reason for that. That good reason essentially is this: if a decision is going to be made on a factual basis, persuading someone to change their mind is much more difficult than persuading someone to approach the matter or rather influencing someone who has an open mind. And there is the SP judgment in the Court of Appeal, which we've referred to in our statement of case, makes that point, for example. That explains why the language of L is you should be consulted before a decision is taken. Now, in this case, the problem is the only consultation occurred after the first decision when the appellant was faced with that difficult problem of trying to persuade someone essentially that they were wrong. Now, that is the only consultation that was then relied on in relation to the second decision, and there were no safeguards essentially put in place in relation to that consultation to essentially ensure that, to the extent possible, it was approached with an open mind. And one can do that. One can, for example, ensure that a more senior officer is involved in the second decision-making. One can somebody who's not involved in the first decision-making. But none of those safeguards were put in place. And that's relevant for two reasons. Firstly, it's a freestanding issue. But secondly, it feeds again potentially into proportionality, because obviously the extent to which there are safeguards in place to ensure that somebody's a proper account is taken of somebody's answers to the allegations it is relevant to proportionality, because it's easier to justify disclosure in circumstances where there hasn't been full disclosure.
Can you just tell us what your case is that this gentleman would have said had he been consulted, which would have added to the information?
Well, my lord, the first answer is that because of what I've said about open, that in one sense it's what he would have said anyway, but it would have been considered by a different decision maker. The second point I would make is that, of course, what he was applying for potentially was a different job, and what he would have potentially said was, I'm still suffering in terms, or I'm still struggling in terms of time. Sorry, in terms of, not in terms of time, I'm...
Employment.
In terms of employment.
Yeah.
And it's potentially relevant, you know, if the position were that the impact on his employment would have been limited, well, that would have been relevant potentially. I have realised that I've misread the clock, and so I finished half an hour ahead of time. But I
that is nothing to apologise for.
I think it's the only time in my career I've managed to do that. But I'm sure it's not a problem.
No.
But it does mean if anyone has any questions, I am.
Thank you very much. Ms. Davis, do you want to take up the time that's still available? Or? Ms. Davis? Ms. Richards.
My Lords, I'm going to deal with the issues in the following order. I'm going to deal with the substantive Article 8 issue of proportionality first. I'm then going to deal with the procedural fairness point. And then, if I have time, I'll deal with the role of the appellate court point. If I don't have sufficient time, then that's an issue that my learned friend Mr. Moffat will be addressing in any event, and the respondent whom I represent makes common cause with the Secretary of State on that issue.
Right.
And obviously from the perspective of the Chief Constable, it's the proportionality and fairness of his decision-making process which is the key importance for him, rather than the issue of the role of the appellate court, obviously important to the court, perhaps to the other parties, including the Secretary of State, but less so to those whom I represent.
Yes.
So I'm going to start, if I may, with the statutory provisions, which we haven't yet looked at. I'm conscious the court will have considered them in reading the case. The relevant provision at the time of the decision is behind tab 2, volume 1 of the bundle of authorities, MS 441. And this is section 113B. The enhanced criminal record certificate regime. Picking it up at the top of page 442 in subsection 3, an enhanced criminal record certificate is a certificate which gives the prescribed details of every relevant matter relating to the applicant recorded in central records and any information provided in accordance with subsection 4. Pausing there, relevant matter means convictions and cautions. Obviously there is a complicated issue which happily we don't need to go into as to what constitutes a relevant matter, what doesn't, but essentially that's convictions and cautions. Information provided in accordance with subsection 4 takes us directly to the subsection, which was the subsection in play in the present case. Secretary of State must request the Chief Officer to provide any information which, in the Chief Officer's opinion, might be relevant for the purpose described in the statement under subsection 2. That's the statutory prescribed purpose. There are a number of them set out in regulations. You have the details in my learned friend Mr. Moffat's written case, but essentially assessing suitability to hold a taxi licence is one of the prescribed purposes. And then B ought to be included in the certificate. So the first point is that section 113B4 is, by its very nature, concerned with information other than convictions and cautions. And the very purpose of section 113B4, therefore, is to permit, indeed to require, if the criteria in subsection 4 are satisfied, the inclusion in the enhanced criminal record certificate of information that has not resulted in a conviction or caution. And that was confirmed, it's obvious in my respectful submission from the statute, but we see it in the Court of Appeals judgment, the judgment of Brian Levison in the case of P. I'll just give my Lords the reference, if I may. It's Authorities Bundle 5, tab 45, MS 1875, paragraph 63, where he says this: given the information that can be put in an ECRC, which need be no more than soft intelligence, Parliament has made it clear that it's not an answer to the need to protect the public that references should be limited to criminal convictions. The objective, clearly, of the inclusion of that information in the ECRC and onward disclosure to the registered person is the protection of the health, rights and freedoms of others, in particular vulnerable persons. And again, I'll just give my Lords, because this is not an issue, two references in that regard. The T case, judgment of this court, Lord Wilson's judgment, Authorities Bundle 4, tab 39, MS 1678, where he talks about the objective behind this regime being supremely important. And then the L case, which I'll come on to in a moment, but just for present purposes, in terms of objective, it's Authorities Bundle 1, tab 5, MS 527, refers to the pressing social need that children and vulnerable adults should be protected against the risk of harm. And it's common ground that that's a legitimate aim for the purposes of Article 8. And so this is a statutory scheme which recognises, and this is the very purpose of the scheme, that there's an important public interest in certain employers, it's only registered persons, and others in a position of responsibility, such as taxi licensing authorities, which is the relevant factual context for the present case, being able to obtain information about allegations, complaints, concerns that have not resulted in a conviction, so that they can take an informed decision as to the suitability of that person, either for a particular post, a particularly sensitive post, or for a particularly sensitive licence. And before I leave the statutory scheme, just a couple of further observations. Firstly, disclosures not to the world at large, unlike some of the other cases, or to members of the public. It is at most to the registered person who's confirmed that the certificate is required for the purpose of what's called an exempted question and a prescribed purpose. I'm not going to go into the detail of that. Again, they're set out in the Secretary of State's written case. And onward disclosure by the registered person is an offence, save in certain defined circumstances. That's section 124 of the Act. You don't, I'm afraid, have that in the bundle. Final point in relation to the statutory scheme, by way of introduction, it's clear in our submission from the terms of section 113B that Parliament has made the Chief Constable the primary decision maker as to whether and if so what information should be included in an ECRC. And that's relevant to the question of institutional competence and weight. Now, the leading authority on section 113B is the decision of this court in the L case. That's in the same volume of authorities, tab 5, starting at MS 505. And there are a number of points to be drawn from this court's judgment in L. Firstly, common ground, disclosure of information under section 113B4 will be an interference with the individual's Article 8 rights in virtually every case. That's, as I say, not an issue. The reference is Lord Hope's judgment, paras 22 to 29. That's MS 520 to 522. And Lord Neuberger's judgment, paragraph 68 to 73, MS 533 to 535. Secondly, and if the court would turn to paragraph 77 of the judgment, MS 536, the Supreme Court recognises in paragraph 77, just below the letter C, that the material that is contemplated within section 113B, the references in the judgment to the identical earlier provisions in section 115, may frequently extend to allegations of matters which are disputed by the applicant or even to mere suspicions or hints of matters which are disputed by the applicant. It's paragraph 77, page 536.
Sorry, just to be clear, this is Lord Neuberger.
This is Lord Neuberger.
Was his part of a majority?
Yes.
Was.
Yes, it was. So the statutory provision introduces a two-stage decision-making process. Only the second is an issue here. First of all, the Chief Constable must form an opinion as to whether the information might be relevant for the prescribed purpose. And that's addressed by Lord Hope, whose judgment reflects the consensus of the court. But the only dissent was Lord Scott, my lord, on the issue of whether Article 8 was engaged. Lord Hope, paragraph 39, MS 526 to 7, bottom of page 526, picking it up just below the letter H, perhaps at H, question whether the information is relevant will depend on the facts of the case. By the terms of the statute, it's for the Chief Constable or his delegate to form an opinion on that issue. In forming his opinion on relevance, the officer must ask himself whether the information might be true, or if it might be true, he must consider the degree of connection between the information and the purpose described. So that's the terms in which Lord Hope puts it in paragraph 39. And the appellant has at all times accepted in this case that the first limb of section 113B is satisfied.
I'm sorry, you've always accepted?
The appellant has always accepted that the first limb, the relevance limb,
Yes.
in section 113B4 is satisfied.
Thank you.
The officer must then form an opinion, this is the second limb of the subsection, as to whether the information ought to be included in the certificate. And if the court turns on to paragraph 42 in the judgment of Lord Hope, page 527, there he says that that issue is essentially one of proportionality, pressing social need, and the applicant's right to respect for private life, and he emphasises the importance of striking the balance in the right place. And he confirms at 45, paragraph 45, page 528, that neither consideration has precedence over the other. Lord Neuberger then sets out in his judgment a number of different, and he identifies sometimes competing factors that will have to be weighed up by the decision maker in making the decision as to whether the information ought to be included. And that's paragraph 81 of Lord Neuberger's judgment, MS 537, where he says this: having decided that the information might be relevant, the chief officer then has to decide whether it ought to be included. There will often be a number of different, sometimes competing factors to weigh up. And then he identifies examples of factors which could often be relevant: the gravity of the material involved, the reliability of the information, whether the applicants had a chance to rebut the information, the relevance of the material, the periods that elapsed, and the impact on the applicant of including the material in the ECRC. Now, leaving aside the issue about whether the applicants had the opportunity to rebut the information, because I'll deal with that when I deal with procedural fairness. But you'll see there 5 factors being identified: gravity, reliability, relevance, currency, or lapse of time, and impact on the applicant. And the guidance set out in the judgments of Lord Hope and Lord Neuberger has been followed and applied by the Court of Appeal and the High Court in a significant number of subsequent cases. The only one I'm going to ask the courts to look at in any detail is the A case.
Yeah. But when Lord Hope talked about whether the applicant has had a chance to rebut the information, in the present case, would one not be looking primarily at the opportunity which he had in the criminal process?
Yes, one would. But as you will see, I hope, when I make my submissions on procedural fairness, because of the particular chronology of this decision-making process, the decision-maker at the time of taking the decision under challenge also had the representations that had relatively recently been made in the context of the complaint or appeal against the first decision. So they had both. My Lord is absolutely right. A chance to rebut the information is often something that may be afforded through the process of the criminal trial.
Do you endorse Lord Neuberger's observation of paragraph 77, Ms. Richards, that the threshold for inclusion is subjective and very low?
Well, Lord Neuberger in paragraph 77 is talking about the first part of the statutory exercise.
Yes,
So
he's not talking about proportionality.
He's talking about the first thing there.
Talking about
yes.
the threshold.
But yes, in terms of the first step, forming an opinion as to whether it might be relevant, that is a relatively low, and the statute obviously provides subjective exercise.
I'm just trying to think myself into the position of somebody who's charged with making these decisions. Is there a real probability that they're going to be very risk-averse?
Well, I don't think one can make any particular assumption that way, one way or another.
Can't one?
No.
Right.
The decision maker will have to balance a range of different factors, as Lord Neuberger sets out, it will inevitably be a fact-sensitive exercise. But clearly, one of the key factors, is the very objective of the statutory regime, which is the protection of those who are vulnerable from the risk of harm.
Exactly.
And that is an entirely legitimate exercise. I don't think I would characterise it as risk-averse, but it's entirely proper that one of the factors that will play a significant part in the decision-making process of the decision-maker will be that objective. That's the very purpose of the legislation.
Thank you.
So, my Lords, dealing with the A case, tab 7, starting on MS 607, and just to give my Lords a sentence or two about the facts, so that one can understand some of the observations they've made. That was a case about allegations of mistreatment in a care home, allegations having been made against a nurse. It was an acquittal case, but not just an acquittal case. Employers had said the investigation failed to discover any supporting evidence for the allegations. The ISA had decided not to include the nurse on the barred list. Nursing Midwifery Council had decided no case to answer. And the context of the acquittal was that the CPS had offered no evidence, and she was acquitted. And that's apparent from the head note and also paragraph 15 of the judgment. Turning to the substance of the judgment of the court, page 613, MS 613, paragraph 1. Lord Justice Beatson, picking it up on the third line on page 613, says that's the information disclosed in an ECRC, can include allegations about criminal or other behaviour which have not been substantiated, whether in the courts, in regulatory proceedings or otherwise, as well as details of any recorded convictions. And then skipping to the last sentence of that paragraph, he talks about how balancing the risks of non-disclosure against the right of the individual is a particularly sensitive and difficult exercise where the allegations have not been substantiated and are strongly denied. So again, entirely consistent with what we've seen in the L case and with the statutory framework. It is not a necessary requirement for inclusion in an ECRC that there has been some form of adjudication or determination or substantiation. The issue is one of balancing the range of factors which will include the reliability of the information rather than whether facts have been substantiated. And then the function of the court is dealt with in paragraphs 36 onwards on MS 627. This is the court at first instance. My learned friend Mr Southey has largely taken you through this. I just want to emphasise 2 points partway down paragraph 37 on page 627. After the reference to Huang, it says this, Lord Bingham also stated that the court must make a value judgment, an evaluation, so that's the nature of the proportionality exercise, it's a value judgment and an evaluation. And then the emphasis that there's no shift to a merits review, it remains the case the judge is not the primary decision maker. And obviously that's been confirmed repeatedly in cases, including, I think, most recently by this court in the Michalak case, the General Medical Council, which is in the Authorities Bundle, tab 35, sorry, Authorities Bundle 5, tab 54, MS 2046. And then paragraph 45, page 629, refers to that which I know this court will be very familiar with, the misbehaving case, and indeed the SB case referred to in paragraph 44. Errors in the reasoning process doesn't render the decision disproportionate. Obviously, it entirely accept as a matter of principle, it may affect the weight to be given to the judgment of the primary decision maker. And then paragraph 61 on page 633, the court says this: it's important not to forget that although it's for the court itself to assess proportionality, the process is essentially an evaluative one rather than one of determining a hard-edged question of fact. And then Lord Justice Beatson goes on to explain that's one of the reasons why the starting point of the court is to give appropriate weight to the conclusions of the decision maker. And then skipping about halfway down that paragraph, what the court has to do in assessing the proportionality of a disclosure of disputed material is to consider the state of the available material, as its task is not to determine the truth or falsity of the allegations, but whether the allegations or some of them are reliable enough to justify disclosure. In the vast majority of cases, there'll be no need to make findings of fact when assessing reliability. And again, that is an accurate reflection, in my respectful submission, both of the statutory scheme and of this court's judgment in L. It's not for the decision maker or the court to determine are these true or false, but are the allegations sufficiently reliable when balanced against all the other factors, including, of course, the impact on the individual, to justify inclusion in the ECRC. And then paragraph 66, top of MS 635, there's a criticism of the judge at first instance for having treated reliability as a threshold question, which in my respectful submission is an error that my learned friend's submissions also fall into. And then the court continues, there's no real dispute between the parties as to the correct approach. This is to put reliability into the balance, along with the other relevant factors such as gravity, relevance, the period that's passed, the impact on the individual, whether the individual's had a chance to rebut the information. Those are the Neuberger criteria. And then the conclusion of the court is the judge didn't make reliability a threshold factor rather than a balancing factor. Now, I'm not going to take the court to what the decision was on the facts of that case, but the outcome of that case, and indeed of various other first instance and Court of Appeal judgments that you have in the authorities bundle, show very clearly the fact-sensitive nature of the exercise. And can I just briefly give the court references to 4 cases? I'm not going to take you to any of them, but they show how the primary decision maker and then the court balances these various factors. And I'm going to give you references to 2 where disclosure was found to be disproportionate and 2 where the judgment was the other way. So the first is RK and the Chief Constable of South Yorkshire. It's Authorities Bundle 4, tab 34, MS 1554. And there the judge considered gravity, paragraphs 32 to 35, MS 1564. And these were matters, he said, that were at the lowest end of the spectrum of sexual offending. He considered reliability, paragraphs 36 to 40, concluding at MS 1565 that these were allegations on the particular facts that were inherently unreliable. He then considered lapse of time. The allegations were of events 9 to 10 years previously. That's MS 1565 to 6, paras 41 to 3. And then impact. And concluded on the facts it was a disproportionate disclosure. The second case, which shows again a similar approach, is the case of P and the Chief Constable of Thames Valley Police. Authorities Bundle 4, tab 38, MS 1645. Again, the process that is undertaken was to consider gravity, paragraph 24, MS 1650. And these were the most vulgar and explicit words that were used, not criminal conduct. Reliability, paragraph 25, MS 1651. Relevance, paragraph 27, MS 1651 to 2. In fact, the individual wouldn't, it was found, be working with children, and that obviously affected relevance. And then lapse of time, MS 1652, paragraph 30. And again, putting those factors together, disproportionate. And then really exactly the same exercise in 2 further cases, but with the conclusion in those cases being balancing these various factors, the disclosure was proportionate, is BW and the Independent Monitor. That's Authorities Bundle, Volume 5, tab 42, MS 1786. Also an acquittal case. Para 41, MS 1792, the court says there's no rule of law which prevents an allegation that results in an acquittal being included in a certificate. And then the court goes through paragraphs 47 and 49, MS 1793, the various factors, gleaning them again from the L judgment as well as by that time from the statutory guidance. And then the conclusion, paragraph 85 there, MS 1799 to 180, not an easy decision, but relevance, risk sufficient to justify disclosure. And then finally, and I cite this because it's a case where, again, there had been an acquittal in similar circumstances, one person's word against another. KC in the Police Service of Northern Ireland, Authorities Bundle 5, tab 44, MS 1822, and it's paragraph 77 onwards, MS 1843 to 1846. And what the court said there is acquittal is a significant outcome, but what should be taken from the acquittal in that case was that the jury wasn't satisfied the case against A was proved beyond reasonable doubt. Overall, the court found that the disclosure was proportionate. And so the guidance that this court gave in L has been routinely applied by decision makers in first instance judgments and from time to time by the Court of Appeal in the way set out in those cases.
In all those cases, the Judicial Review Court is deciding for itself whether it's proportionate, but giving weight to the Chief.
Yes, in the first instance court, because there is no dispute between the parties as to what is the role of the first instance court. It's deciding upon proportionality, giving appropriate weight to the decision of the decision maker. And in 3 of those cases were acquittal cases. In 1, the police had decided no case even to answer.
The reason you're referring us to them?
The reason I'm referring is to show that what's undertaken in every case is a balance of these range of factors identified by Lord Neuberger. There is no requirement to be satisfied on the balance of probabilities that the allegation is true, and there is no...
that has been argued, has it?
No.
That has not been argued.
Well, my lord, it is argued very firmly in my learned friend's written case.
Well, I haven't understood his oral submissions to amount to the proposition that the decision maker must be satisfied of the truth of the allegations before.
Well, my lord, I'm going to deal with the submission. I'm entirely accept my learned friend hasn't made oral submissions to that effect, but it's very clearly set out in his written case, although hasn't been argued hitherto in the history of this case. It wasn't argued before His Honour Judge Rayner or before the Court of Appeal. So, my lord, before I turn to the facts of the case, can I deal with
he puts it the other way around, doesn't he? He says might be true isn't enough.
Well, he does say, but the reason he says might be true isn't enough is he says because you have to be satisfied more likely than not is true.
Well, maybe.
I understood it. The point was that there had been a confusion in the way it had been approached below as to which test was being applied.
Yes, and I will obviously deal with that when I deal with the facts of the case. But if I might just draw attention to my learned friend's case, written case, and because this is why I am going to deal with this unless my learned friend is saying what is in his written case is no longer what he argues. For example, MS 77, paragraph 4.21, disclosure should require a matter to be proved on the balance of probabilities. And that, my learned friend, it's a central thrust of my learned friend's written case. And indeed, it's why we've dealt with it in our written case, as has the Secretary of State. And so I'm just going to, without, I think, needing to take you to any authorities, because you've seen the most relevant ones, explain why we submit that.
Can I just, because it may assist, the position I think we've taken, I was looking for the other reference, was 4.21 should be read with 4.20, where we say, in the appellant's case, essentially, that given the gravity of the allegation, it shouldn't have been disclosed unless established on balance of probabilities. We do say on the spectrum, balance of probabilities is as the guidance indicates, is a key factor, but we've not, I think as with anything in proportionality, it would be very difficult to say there's a rigid rule, but we do say it's highly significant, but not necessarily in every single case.
Thank you.
Well, I'll make the submissions I'm going to, because whether they are limited to this case or advance as a matter of a more general proposition, which is the way the written case was framed, obviously I need to deal with it, and I'll do so briefly. The appellant accepts, as we understand it, that acquittal doesn't provide a bar to disclosure. The suggestion that's made, at least in relation to this appellant's case, that disclosure could only take place if the allegations were proved against him on the balance of probabilities, we say is wrong. Firstly, such an approach is inconsistent with and derives no support from the terms of the statute. Secondly, it derives no support from and is inconsistent with the terms of the Supreme Court's judgment in L, in particular Lord Neuberger at 77, which the Court's already seen. Thirdly, it derives no support from any other domestic case law and has never been the approach taken by the courts. Fourthly, there's nothing in Article 8 or any Article 8 case law that would suggest there is any kind of threshold or requirement that an allegation must be proved on the balance of probabilities or be more likely than not to be true, either as a matter of generality or in a case of this kind where the allegations are grave. Fifthly, it's a submission, in our respectful submission, that's unsound and illogical for the reasons set out in my learned friend Mr. Moffat's written case, paragraph 76, MS 126. Sixthly, and perhaps this is the key point in relation to the facts of the present case, it involves introducing a standard of proof for disclosure in either acquittal cases generally or acquittal cases where the offence that had been alleged was a grave one, which is different from that applicable to other relevant information that might fall within Section 113B. And we say it would be a very surprising result if Article 8 had the effect of introducing a higher standard of proof for the disclosure of an allegation that had resulted in prosecution and had thus satisfied the CPS test, and I'll come back to what that test is, than for an allegation which didn't even get that far. And so we say that can't be right, and it can't be right that the graver the allegation, the more evidence there must be to justify disclosure. The graver the allegation, the greater the case there will be for disclosure, because the risk or potential risk is a greater one. The seventh and final point in relation to this is a practical point. It's unclear to us how the police is supposed to go about this process of reaching a view on the balance of probabilities. There will be some individual cases where there has been a full investigation and decision by a regulatory body, such as the Nursing and Midwifery Council or General Medical Council, on which the police could perhaps rely. But the vast majority of soft intelligence that falls within an ECRC is not of that nature. It's not the exercise envisaged by Section 113B4 that the police conduct some form of mini-trial. Not only will that lead to delay, holding up potentially the process of employment, but it could be counterproductive because, of course, if the police, in order to put something in an ECRC, are saying, well, we are positively satisfied on the balance of probabilities that this is true, that is far more likely to be a killer blow to the prospects of employment than the kind of disclosure made in the present case, which set out the fact of the allegation and the fact of acquittal. But standing back, and again, just as a matter of generality before I turn to the facts of the case, we say that what Section 113B4 requires is an evaluation of reliability, not a determination of truth or falsity to any particular standard of proof. And the case law in the Act clearly envisage it permits the inclusion of information that's neither been substantiated nor disproved. And the chief officer, the chief constable's task, is to assess whether the allegation or the information is reliable enough to justify disclosure as part of the overall process of evaluation, weighing all the other factors which Lord Neuberger identified.
Well, I mean, it also strikes me, fortunately, we're not having to deal with the Article 6.2 argument, but whatever the position might be, if what the certificate contains is a neutral narrative that an allegation was made and the person stood trial and was acquitted, I'd have thought the Article 6.2 problems would be greater if you were, if the police were saying, notwithstanding the acquittal, we consider on a balance of probabilities this man is guilty of rape.
Yes.
But there's no imperative in the legislation for the police to express such a view, is there?
No, they must. What they must do clearly is assess reliability, but reliability doesn't require them to adjudicate upon truth or falsity and determine which they think is the correct objective state of affairs.
It depends what you mean by adjudicate. You've got to make a decision whether there is enough in it to justify the damage it will do.
Yes. Yes. My Lord, I don't disagree with that, but what you don't have to do is say, I am satisfied that on X date, this person sexually assaulted the complainant.
No.
You have to be satisfied that what you have is sufficiently reliable to justify the interference with the individual's Article 8 rights. And in undertaking that exercise, you will then look at those factors of gravity, lapse of time, and so on, and relevance. Of course, the more relevant, the graver the allegation, the more current it is, the more relevant it is, the less may be required by way of reliability.
Well, I understand that point, but what should you say to yourself about the likely impact? You've made the no doubt technically correct point that the object of the exercise of the certificate is to allow the potential employer to make a reasoned decision. But in reality, with this sort of disclosure, what should you be saying to yourself about the likely impact?
Well, what you should be saying to yourself on facts such as these will be, it may well adversely impact upon the prospects of obtaining employment in their chosen profession.
Chances of him getting a job as a taxi driver or a teacher are pretty nearly zero, aren't they?
Well, that may or may not be right. There is a very recent Court of Appeal decision. It's a decision of my learned friend, a decision which my learned friend, Mr. Southey, represented the appellant. A decision called SD, we don't have it in the bundle, where the court set out its view that whilst inclusion in a certificate of some information may correctly be characterised as a killer blow, was Lord Newburger's phrase in the L case, in relation to acquittals, it won't necessarily have that effect. But that wasn't the basis upon which the respondent proceeded in this case. The respondent proceeded upon the understanding that there might well be an impact. It at least carried with it a significant risk that he wouldn't be able to work in his chosen profession.
Well, yes, it may be that the impact is justified, but the likely impact is severe.
Yes.
I would have thought was pretty well obvious.
Well, yes, I must say, the SD case suggests it may vary from case to case, but that wasn't the basis upon which this decision was taken. It's not the basis upon which I argue the facts of this case.
Okay.
Might I just deal with my learned friend's reliance upon the guidance? That didn't exist at the time of the decision. The statutory requirement in 113B4A for there to be guidance to which regard should be had postdates the decision in question. My learned friend, Mr. Moffat, will address the meaning of the guidance in that paragraph 18 to the extent that he needs to, because it's his client's guidance.
Well, do you suggest that it should be left out of account?
I suggest it should be entirely left out of account. It is, at most, guidance in any event which Chief Constable should have regard to but do not have to follow. That's clear from paragraph 2 of the guidance. But in any event, it's wholly immaterial to the present case. There was no such statutory obligation and no such guidance in existence at all.
But does it not express a standard to which a decision maker should aspire? If it doesn't, why is it contained in contemporary guidance?
Well, without wanting to tread on Mr. Moffat's toes, if one just turns to the guidance in Volume 5, Tab 53, MS 2038. Firstly, it's paragraph 6 of the guidance 2039, which talks about its status. And that derives from the provision of the Act set out in paragraph 5, which postdates the decision in question. And then that which is set out in paragraph 18 is in fact part and parcel of the guidance in relation to Principle 2. Principle 2 is on page 2040, between paragraphs 11 and 12. And that's as to relevance, which is the aspect of the Chief Constable's decision that isn't challenged in the present case. In any event, subject to anything my learned friend Mr Moffat might say about paragraph 18, the last sentence, if construed in the way in which my learned friend Soddy sought to construe it, is, we say, inconsistent with both the statute and the case law, for the reasons I've already given, but also inconsistent with the second sentence of paragraph 18.
Yeah, well, that's a question of the application of the guidance, not its relevance. I don't know. We have your position on that. But we move on.
And so turning then to the facts of the case, if the court would turn up the decision in question, it's MS 322. It's in the appendix, page 192 of the appendix. And I should say this is a standard form document, not a document devised by the Chief Constable of the Greater.
Sorry, Miss Richards, I can't find the document at the moment.
It's MS 322.
In the appendix.
In the appendix, using the appendix pagination, it's page 192.
Thank you very much.
And it's a structure that follows what, in fact, was some non-statutory framework templates and so on at the relevant time. We see, first of all, on page 193, that it identifies the information held by the police. It's page 322 to 323, the memory strict pagination. And then there is a preliminary decision-making process, MS 324 to 5, pages 194 to 5, in section 2.2 of the form. Hits, that means relevant information that's been identified that are not being discarded. So there's a preliminary assessment of whether the information should be discarded, i.e. not go any further, or whether there should be further consideration. And then we have the substantive consideration starting on MS 328, page 198 of the appendix. And it starts, the bottom box on page 199, MS 329, with a series of bullet points. Review of the information, noted the views of the risk assessor, consider the human rights of all parties. And then I'm going to come back to my learned friend's criticism of the use of the word victim, if I may, when I deal with his submissions. But there is the identification of the nature of the potential risk, issues going to gravity and relevance. This was an allegation from someone who had been drunk, young, a lone female, making her vulnerable, passenger in the taxi. And then over the page, alleged offence committed in the PAF, that's position applied for. So again, that goes to relevance. This was an application that was going to the question of whether there would be a taxi licence granted. And then we have the bullet point that's been criticised by my learned friend and to some extent by the judge, but taking it in stages. Sufficient evidence for the CPS to authorise the applicant being charged, indicating they believe there to be a realistic prospect of conviction.
So far, so good.
So far, so good. And in terms of what the evidential test is, I can provide copies to the court if need be, but I have got the relevant extract from the CPS code. And in terms of the evidential test, a realistic prospect of a conviction means that an objective, impartial and reasonable jury, or bench of magistrates or judge, properly directed and acting in accordance with the law, is more likely than not to convict the defendant.
What's the citation for that, please?
That's paragraph 4.5 of the CPS code. It's called the Code for Crown Prosecutors.
And what's the MS number, please?
We don't have it in the bundle, do we?
We don't have it in the bundle, I'm afraid, but I can, we can arrange for copies to be provided.
Yes, thank you.
As an issue arose earlier as to what it is.
So the more likely than not comes in as part of the definition of
Precisely, as part of the evidential test, as part of the realistic prospect of conviction test. My Lords, we accepted before the Court of Appeal and accept today that the last sentence of that bullet point contains really a non sequitur. And it is, I think, clumsy wording that it was intended to convey the CPS evidential test.
Well, both those two, the last two sentences are wrong, aren't they?
Well, yes, it's not really a question of belief, I accept that. It's a question of objective evaluation.
Not for the CPS to decide whether the complainant's telling the truth or not. They're not doing their job if they're trying to do that. And secondly, the equation of balance of probabilities more likely true than false to realistic prospect of conviction, as you say, simply doesn't follow, does it? It's quite an important misconception, isn't it?
Not when one reads, in my respectful submission, the decision as a whole, and I'll come on to what's said at the end. In terms of CPS not believing the allegation, perhaps not the right verb to use, but that goes to the question of the CPS must have assessed the evidence as sufficiently credible and reliable to justify charging.
Yes.
The non sequitur in the last sentence is to say that the fact of charging indicates, on the balance of probabilities, objectively the allegation more likely to be true than false. In fact, what that really should be conveying is the CPS test incorporates an element of balance of probabilities in the way in which I've described. But there's nothing wrong in any event, leaving aside that last sentence of that bullet point, there is nothing wrong as a matter of principle with the starting point being this was a case, unlike many other soft intelligence cases, unlike a number of those in the authorities to which I referred, the first instance authorities, where the CPS considered that there was a realistic prospect of conviction, there was sufficient credible and reliable evidence to bring the charges. And that's a perfectly proper starting point in just the same way that if the CPS had decided that the evidential test was not met, that would have been a perfectly proper starting point for the decision maker. And indeed, in one of the first instance cases, that was the very position.
Well, that was the position in Lang, in Mrs. Justice Lang's case, wasn't it? L.
They'd offered
no,
no evidence.
I beg your pardon, A.
In A, they'd offered no evidence, yes. And in one of the others, I think it didn't even get to that stage. And then the next bullet point is, in my respectful submission, again, perfectly proper. It's looking at the question of what inference should be drawn from the jury's decision. There will, of course, be cases, individual cases, where the acquittal provides a lot of information. It may be that there was an acquittal because the case was thrown out at half-time. It may be that powerful evidence emerged in the course of the trial of an alibi nature or mistaken identity. It may be that the chief witness's evidence completely collapsed. This was not such a case, as the judge's summing up makes clear. This was a case in which ultimately it came down to one person's word against another, criminal standard of proof, the jury did not convict. And so the inference that the decision maker draws from the acquittal there, which His Honour Judge Rayner and the Court of Appeal both said was a proper inference, is in my submission just that, a perfectly proper inference to draw. And of course, the reason for dealing with that issue, as we'll see when I deal with the procedural fairness challenges, is because the appellant's representations were essentially saying, well, I'm innocent. I was acquitted. You can't include this. And so this decision has to be looked at in that context. And then there's this express reference you'll see in the next bullet point to the applicant's letter to the IGU, that's Information Governance Unit, that particular acronym, part and parcel of the police. And so there the decision maker is expressly dealing with a particular issue raised by the applicant about another male's DNA being found. And then the decision maker sets out what the evidence was at trial in relation to that. It didn't provide evidence that there'd been sex with anyone else on the evening of the incident.
Well, it can't have had anything to do with whether the incident that was alleged happened in any event.
No, it can't. But there is the decision maker.
There were only two of them in the taxi.
Yes. And this wasn't a mistaken identity case or anything of that kind. So there was the decision maker, however, expressly dealing with the point that was troubling the appellant and that he had raised expressly in his complaint. And then there's consideration of the forensic evidence, and correctly, what's set out there is that the forensic evidence was neutral. It didn't cast any doubt one way or another or assist in assessing reliability. Then reference to the medical evidence, saying, well, that's consistent. So that's a factor that might help in terms of assessing reliability. And then reference to inconsistencies. And again, this is the decision maker expressly dealing with the points raised by the applicant, where he says there were many inconsistencies in the account. And the decision makers looked at what the judges said, and they're set out in a way which isn't challenged as being irrational or inaccurate in terms of the treatment of the evidence. And the decision maker explains why those inconsistencies don't lead to a conclusion that this is inherently unreliable material. And then again, a number of other factors about evidence of distress. So there, the decision maker is identifying a factor that could be said to support the reliability of the account. Reference to the applicant's account. Again, my learned friend complains about this, but this is a point being identified in the applicant's favour. Consistency is in his favour, but that doesn't fundamentally undermine the reliability of the evidence, or the unreliability of the allegation. And then the question, no indication of the victim having any motive to make a false allegation, and matters set up there. Again, entirely proper. A number of the other cases, the A case, Mrs. Justice Lang's judgment, the Court of Appeal's judgment is one, is where there was evidence as to what might have motivated the complainant to make the allegations. There was specific evidence in that. In the RK case, one of the first instance judgments I gave my lords the reference to a little while ago, that was a case in which there was evidence of collusion and an ulterior motive on the part of the school children or schoolgirls who might have, as to whether they might have made up the allegation. So it's a perfectly proper factor for the decision maker to take into account when looking at reliability. And these points all go to the question of reliability. And then...
So can I interrupt just for a moment, just to be clear as to what exactly the significance is of this decision? There's on page MS322, we have a decision made by somebody named there on the 1st of March 2012.
Yes, can I...
Now, that's the original decision.
No, no. So none of this has anything to do with the first ECRC.
No.
I hope the chronology will become clearer when I deal with the procedural complaint.
Right.
So this is the second application that was made by the appellant
Yes.
for an ECRC in connection with taxi licensing.
Yes.
You'll see on that box on page 322, Appendix 192, disclosure officer and the name given there, 23rd of February 2012.
Yep.
So that's the person who just looks and sees what information is on the system.
Yes.
Then the risk assessor and the exercise undertaken on the 1st of March is the exercise that's undertaken on pages MS 324 and 325, pages 194, 195 of the appendix. That's the preliminary consideration that's given by someone reaching a very provisional view. Is this to be discarded? In other words, it's not going to be included. Or is this something which should be considered further?
Yes.
And that was the decision maker, Mr. Connor, on the 1st of March. And then that decision maker, or that assessor, having said, well, this isn't something which I'm going to discard, it's potentially relevant. It then goes for a full consideration by a separate person, and that's the exercise one sees on MS 328, paragraph 198, by Ms. Wilson on the 28th of March.
Now she refers to the recent review by the IGU.
Yes.
What's she referring to?
She's
there?
referring there to the fact that after the first ECRC in the previous year, in 2011, the appellant had made a complaint.
Right.
I think my learned friend referred to it as an appeal, whether it's a complaint or an appeal probably doesn't matter. He'd made a complaint both to the Criminal Records Bureau and to the police. And the police IGU, Information Governance Unit, had looked at that. And it had been Ms. Wilson who undertook that exercise. So only a few days before doing this, she'd considered his complaint.
Right, so the disclosure
And they're in
there is
identical
the disclosure in the first certificate.
My lord,
So the disclosure referred to, the IGU found the disclosure was compliant, etc.
Yes.
That's the disclosure in the first
the
certificate.
IGU reference refers to the first certificate. But the decision-making that one sees here is all in relation to the second
So
certificate.
the IGU is the reference to the complaint following the first certificate?
Yes.
Thank you.
And then bottom of page MS 330, page 200 of the appendix, Although the IGU review, so there's the review that she'd undertaken when looking at the complaint in relation to the first certificate, had raised that the acquittal indicates that the allegation might not be true, the legislation and guidance is clear that allegations that might not be true can be disclosed. Absolutely correct.
Yes. And then when she refers immediately then to the test required, what's she referring to there? In the absence of guidance, is it the statute?
It's the statute.
Or some internal?
It's the statute. Well, there was guidance, it wasn't internal, but it was something called the QAF, Quality Assurance Framework, which was common to all police forces.
Well, I was going to ask you about that, Mr. Richard, because the various bullet points that you were taking us through just now on what is, for me, page 200, look to the untutored eye at least as if they're freshly written,
Yes.
individually written for this case. But once you get to the one which begins, although the IGU review has raised, after the test, I wondered whether what followed might just have come off the word processor. Because it says so many different things all at once. I believe that the information is more likely to be true than false, and is not lacking in substance, and it's reasonable to believe that it might be true. And where's all that come from?
Yes.
It looks like a form of words.
Well, I don't know the answer to that. Okay. I can check the, I think I've got a copy somewhere of the Quality Assurance Framework. If not, I can get it online over
It could have come from some sort of internal document, I imagine.
Yes, but I'm also able to ask Ms Wilson,
Okay,
so I
right.
can do that. Of course, my learned friend highlighted, I believe the information is more likely to be true than false. Of course, the judge was critical in some respects of that, and she didn't need to go that far. But what matters in our submission is what it continues is not lacking in substance and is reasonable to believe that the information might be true.
Well, if that was a separate judgment, yes, but my worry is that I wonder whether it is.
Well,
maybe. Anyway, there we are.
well, my lord, I mean, the document stands for itself. Obviously, the court is entitled to draw such inferences as it considers appropriate from it. And then the decision maker goes on to look at currency, lapse of time. It's relatively recent, obviously was at the time, 5 years have now elapsed. Very serious, not minor, so that goes to gravity. And then they look at the risk of harm. If the alleged behaviour were to be repeated in the position applied for, vulnerable people could be caused serious emotional and physical harm. And then impact. Disclosure will have an impact on the applicant's human rights, as he may fail to gain employment in his chosen profession. So there's a clear recognition that it will have that impact. And then the decision maker correctly observes that doesn't prevent him from gaining employment in another profession which doesn't require an enhanced CRB check. So the impact of disclosure will prevent him or may prevent him from practicing as a taxi driver, but obviously doesn't go to the question of whether he becomes unemployable for all purposes. And so she correctly says disclosure of this allegation will not prevent the applicant from gaining all forms of employment indefinitely. And then really sets out the justifications and the balance in the final 3 bullet points. That, in my respectful submission, is a faithful application of the principles identified in the case law, the consideration of relevance, reliability, gravity, currency, and impact. And then just to complete this document and the facts in relation to the substantive Article 8 challenge, there is then a review by an inspector on page 204 of the appendix MS 334, which deals with disclosure in the first paragraph. Says, I'm Inspector Kynaston of Greater Manchester Police, etc. Deals with the proposed disclosure and relevance to the first paragraph. Then says, looks at the other factors I've taken into account: gravity, reliability, relevance to the post applied for, period of time elapsed, together with the likely impact, and so on. Deals with the wording of the disclosure text, and then having considered the human rights of all parties' potential risks, I agree. I fully agree. I believe the disclosure is necessary and therefore authorise this disclosure as approved information. So that's the final approval that's given by the Chief Constable's delegate. And then you have the actual text of the disclosure on page 205 to 206, 335 to 336. Sets out the statutory test, the allegation, the appellant's response to that, in other words, denial, the fact of charge and the fact of acquittal. So it's a neutral and balanced text. Indeed, no issue's been taken and no challenge has been made to the text itself. My Lord, is that a convenient point at which to stop?
Yes. See you again at 2 o'clock.